Let's get straight to the point. If you've been researching estate planning, you'll have come across those adverts. A lifetime trust, they say, will protect your home from care fees, eliminate your inheritance tax bill, and keep everything completely private. Some of the claims are partially true, most of them aren't, and some of them could leave your family worse off than if you had done nothing at all. In this video, I'm going to cover what a lifetime trust can genuinely do, where the limits are, and what you need to watch out for. First, let's deal with something fundamental. Many people who are sold a lifetime trust do not actually know what the term means. And that's not their fault. It is a vague label that gets applied to several different legal structures, and the difference rarely gets explained. So what is a trust? At its core, a trust is a legal arrangement where you transfer ownership of assets to someone else to hold and manage on behalf of the people you want to benefit. There are three parties involved. You, the settlor, put the assets in, the trustees legally own and manage those assets, and the beneficiaries are the people who ultimately benefit from them. A trust is a legal structure, a container if you like, with rules about who controls what's inside and who gets to benefit. When you set up a trust, you are making two separate decisions. When does it begin and how does it work? These decisions are completely independent of each other, and understanding both is the only way to make any sense of what you are actually being offered. Let's take them one at a time. The first decision is about timing, and there are two options to choose from. A lifetime trust starts during your lifetime. You name your trustees and beneficiaries, sign the documents to bring the trust into existence, and then you transfer assets into it. From that point, those assets belong to the trust, not to you personally. A testamentary trust works differently. It actually sits inside your will and only comes into existence after you pass away. While you're alive, nothing changes. Your assets stay in your name. Nothing needs to be registered and no transfers are made. Once it does come into existence after your passing, your trustees will need to register it with HMRC, but that is their responsibility at the time, not something you need to think about now. Essentially, a lifetime trust is active now, a testamentary trust is a set of instructions for later. The second decision is about structure. How will the trust actually operate? Saying something is a lifetime trust tells you when it starts. It says nothing about how it actually works, and there are several different structures, each operating very differently. Here are three structures used in estate planning. A discretionary trust gives trustees the flexibility to decide who benefits, how much and when. It is the most commonly used structure for family estate planning. An interest in possession trust splits the benefit in two. One person benefits during their lifetime, and when they pass away, the assets go to whoever is named next. Often used in blended family situations. Then we have a bare trust, which is the most straightforward. One named person receives everything outright, most commonly used to hold assets for kids until they turn 18. There are other structures beyond these three, but the same principle applies to all of them. Timing and structure are separate decisions. The timing tells you when the trust starts. The structure tells you how it operates. When someone offers you a lifetime trust, they are describing the timing. They've told you nothing about the structure, and that is exactly where the problems start. Because what tends to fill that gap is a set of claims. Things a lifetime trust can supposedly do for you. There are two claims that come up more often than any others. Let's go through them once at a time. This is the claim you will hear most often, and the area where the most damage gets done. The concern behind it is completely legitimate. If your assets exceed a certain threshold, you are expected to fund your own care. In England, that threshold is currently £23,250. In Wales, it's 50 grand. In both countries, your home is typically included in the assessment. With residential care averaging around £1,300 a week, it is no surprise that people want to protect what they have spent a lifetime building. The logic people are sold goes like this. When you transfer your home into a lifetime trust, you no longer personally own it. The trust does. And if you do not own it, the argument goes the local authority cannot count it as your asset when they assess what you need to contribute to your care. On paper, it sounds pretty straightforward. In practice, it does not work. Local authorities are well aware of this potential loophole, and the rules are designed to deal with it directly. If a local authority decides that you transferred assets into a trust specifically to avoid care costs, even if that was only part of the reason, they can treat you as though you still own those assets. The trust gets ignored entirely. This is known as deliberate deprivation of assets, and councils apply it fairly regularly. There is no time limit on how far back they can look, and it is not purely about timing. If care was a foreseeable possibility when you made the transfer because of your age, your health, or a family history, the risk is considerably higher, regardless of when the trust was set up. Could a lifetime trust have a role in legitimate estate planning that also happens to affect care costs? In very specific circumstances, maybe. But presenting it as a solution you can count on for care fees is not something any responsible regulated professional should be promising. The second claim is that putting assets into a lifetime trust reduces what your family pays in inheritance tax. To understand why this is wrong, it helps first to understand why it sounds convincing. Quick recap on how inheritance tax works. Everything has a tax-free threshold of £325,000. Above that, your estate is taxed at 40%. If you're passing your home to direct descendants, that threshold rises to £500,000 or £1 million for a married couple. The logic people are sold goes like this. When you transfer assets into a trust, you no longer personally own them, and if you do not own them, they cannot form part of your estate when you pass away. No estate, no inheritance tax. And that first part is actually true. Assets held in trust do sit outside of your personal estate. The problem is that HMRC anticipated this entirely. Assets transferred into most lifetime trusts fall under what is known as the relevant property regime, which exists precisely to make sure those assets are still taxed, just differently. There is an entry charge of up to 20% on anything above your available threshold when the trust is set up, a charge of up to 6% every 10 years the assets remain in the trust, and a further charge when assets are paid out to beneficiaries. A lifetime trust does not remove your inheritance tax liability. It replaces it with a different ongoing one. So those are the two claims you will hear most often. And in both cases, the reality is more complicated than it first appears. Which raises a fair question. Who exactly is selling these, and what do you need to know about them? The Association of Lifetime Lawyers published a report in 2025 on the mis-selling of asset protection trusts. 90% of their members had come across clients who had been mis-sold a trust. 90% said unregulated providers were the main culprits. And herein lies the problem. Anyone in England and Wales can set themselves up as a will writer or estate planning advisor with no qualifications, no insurance, and no regulator to answer to. If the advice turns out to be wrong, you may have no way to put things right. And it actually gets worse. Not only are people being sold these trusts under false pretenses, but in 4 out of 5 cases the report found that the provider had also appointed themselves as a trustee of the trust they had just sold, often without the client understanding what that meant. Some people later found they could not sell their own home without the provider's involvement and faced significant costs just to exit an arrangement they never fully understood. And remember, that second claim we looked at about reducing inheritance tax? Perhaps the most striking finding of all of this is that many of these clients did not have an inheritance tax problem in the first place. When you pass your home directly to your kids or grandchildren, you get an additional tax-free allowance of up to 175 grand. For a married couple, that means up to £1 million passing to their family completely tax-free. Many estates fall within that. No trust needed. But by putting their home into a discretionary lifetime trust, they lost that allowance entirely and ended up with a tax bill they would never have had otherwise. They were sold a solution to a problem that did not exist. And that solution created the very problem they were trying to avoid. The good news is that this is avoidable, and it starts with who you take advice from. If someone is applying time pressure or recommending a trust before they have properly understood your situation, treat that as a warning sign. Look instead for a properly regulated advisor, whether that's a solicitor or an estate planning professional regulated by a recognised body, such as the Institute of Professional Will Writers. That regulation means they are accountable, insured, and have a legal duty to act in your interests. The picture is not entirely negative. There are legitimate reasons to set up a lifetime trust and real benefits to doing so. The issue is not that these products should not exist. It is that they are routinely sold to people who do not need them, for reasons that do not stand up. Here's why they actually do make sense. The strongest case is probate avoidance. When you pass away, every asset in your personal name is frozen until probate is granted. That process can take months and cost thousands in fees. Assets held in a lifetime trust bypass it entirely. Trustees can act immediately with no delays and no probate costs. A testamentary trust does not offer that because the estate still has to go through probate first. Next is privacy. Once probate is granted, your will becomes a public document. Anyone can look it up and read it. A lifetime trust works differently. The trust deed never goes through probate and is never publicly searchable. What you owned, who you left it to, and on what terms stays private. One caveat, the trust must be registered with HMRC, so it's not invisible to the tax authority. The privacy benefit applies to the public, not to HMRC. Third is growth outside the estate. When you transfer assets into a lifetime trust, the value exposed to inheritance tax is fixed at the point of transfer. Any growth after that sits inside the trust, outside of your estate, and is never subject to inheritance tax on your passing. Transfer a portfolio worth £500,000 and it doubles over 10 years, only £500,000 is ever exposed to inheritance tax, not 1 million. A discretionary lifetime trust can also last up to 125 years, passing wealth across multiple generations without a fresh IHT charge at each death. Fourth is business property relief. From April 2026, full IHT relief on qualifying business assets is capped at £2.5 million per person, or £5 million for married couples. Business property relief already reduces or eliminates inheritance tax on those assets. A lifetime trust adds value by combining that relief with the growth benefit above, meaning qualifying business assets transferred now are sheltered from inheritance tax, and any future growth on them never enters your estate at all. If this applies to you, please take proper specialist advice. Finally, we have legislative risk. IHT rules have changed significantly in recent years, and there's absolutely no reason to think that's ever going to stop. A lifetime trust is governed by the rules in place when it was created. A testamentary trust only comes into existence when you pass away, leaving it exposed to whatever rules exist at that point. For larger estates, setting up the structure now means you know exactly what rules are applying. Waiting means you don't. So, is a lifetime trust a scam? No. But it is one of the most frequently missold arrangements in estate planning. And the gap between what gets promised and what actually happens can be enormous. If your priority is avoiding probate, protecting privacy, planning around business assets, or managing a large and growing estate, a lifetime trust is worth exploring seriously. If you are hoping it will protect your home from care fees or wipe out your inheritance tax bill, the honest answer is that in specific circumstances and with proper advice, it could potentially help, but it's not to be relied upon. At Elm Legal Services, we've been helping families across England and Wales with estate planning for over 25 years. And we are proudly regulated by the Institute of Professional Will Writers. If a lifetime trust is right for your situation, we will tell you. If it's not, we're going to tell you that too. If you would like to talk through your own circumstances, there is a link in the description to book a free, no obligation consultation with one of our specialists. And if you found this useful, please like, subscribe and share it with someone who might benefit. Remember, a little planning today can make a big difference tomorrow. So, until the next time then, stay safe, stay informed and stay tuned.